Good afternoon, everyone. My name is Katlego Ramantsima. I'm a researcher here at PLUS. Thank you again for tuning in. In the month of October this year, PLUS held a webinar following the release of state land announcement made by the Minister of the Department of Agriculture and Land Reform, Togo Didiza. The webinar sought to interrogate the release of state land and its possible implications on rural populations and the society at large. Our discussions for today follows the official opening of the application process on the 15th of October and the media statement made by the Minister Didiza on Tuesday, the 10th of October, to provide clarification on which land makes up the land that is being released, the progress on the application process, land rights inquiry process, and the alleged illegal evictions on state farms. We continue to question and discuss the significance of this land release gesture towards land reform in South Africa. And this time, we provide a real case of what is at stake following the redistribution of land, of state land in the former homelands. Today, we are delighted to be joined by Alwyn Esterhuizen, a GIS specialist at the Seriti Institute, who will share with us maps of where in the 6 provinces are the 896 promised farmland located. We are also joined by Siyabu Manona. Many of you may know him. He is a student with more than 30 years of experience in the land sector, tackling issues of land administration. Our very own research associate and member of Landness, Dr. Rosalie Kingwill, has published widely on issues on land tenure and property rights and their complex manifestations in South Africa. She also joins us today and details the Gwaiju case following the announcement. And last but not least, we are more than happy to be joined by the expert herself, who lives in Gwaiju, Thembakazi Matsheke, chairperson of the Gwaiju Farm Dwellers Communal Property Association, to share with us how the people's rights and land rights have been infringed on by the sudden state land redistribution process. A warm welcome to you all. Please do not forget to tweet about the webinar. Our Twitter handle is #landreform, as demonstrated on the bottom of your screens. Now, my first question goes to Alwyn. Alwyn, on Tuesday, the minister confirmed that the land in question is not new land, but it is land that the apartheid government earmarked for the consolidation of the homelands and was then held by the South African Development Trust. Are you able to demonstrate to us this land, including, hello?
Thank you, everybody, for joining us. Yes, so it was quite an interesting exercise. What we received was 654 parcels that was made available through the Land and Administration website that is managed by the Department of Rural Development and Land Reform. I know in the media it's reported of 896 parcels or properties that it's been made available, but as per my maps, you will see that it's only 654 parcels. So I'm gonna, from the information that was available, we were able to locate them, and I'm gonna show you on the map of South Africa, it's all the red parcels that were identified. I'm gonna play around with my map so that I can just show you in the northwest. Let's start with Limpopo. All the red areas are the farm portions that was identified through that list. And you can see the distribution thereof. This is the part in Mpumalanga. These ones here. If I go to northwest, you'll see quite a bit in those northeastern sides and coming down here. Obviously, you know, again, like I said from the list, not a lot in the Free State, a lot around the Putaditjaba Kwakwa area. KZN, again, not a lot because of the original tribal authorities there. And going to the Eastern Cape, again, a lot more that was identified. I think we all know that in the Western Cape, there was no properties made available, and also very few in the Northern Cape, again, only here in the northeastern side. Okay, so the interesting part becomes when you say, okay, let's see in relation to the former homelands. Okay, so immediately, let me move this up. You can see all the former homelands here. And again, if I zoom in, you know, this is the Bophuthatswana, former Bophuthatswana, and we can see most of the, well, almost all of them will fall within these, what they call the Bantustan regions. The same in Mpumalanga, Limpopo. There's a few outside. And in case then you can see here in Kwakwa, the ones that I said in Putaditjaba. Yeah, so even in the Eastern Cape, all within that former areas. The layer of the traditional authorities, you know, very much similar, how they're now defined as traditional authorities, which, very interesting for me, it is literally on the boundaries of all these traditional authorities. As you can see there, especially here in Northwest as well, all within, next to the traditional authorities and within the old Bantustan regions. Thanks, Katlego.
Thank you very much for that, Alwyn. Siyabu, we now know where the promised land is located. The minister also played her part by clarifying some aspects about the redistribution process and also assured that there would be transparency through this process. What are your major concerns about this entire process? And can we also hear your view of with regards to why the 896 farms cannot be found on the map that Alwyn has demonstrated to us? And lastly, is this announcement made by the minister bringing anything new to the land reform table?
Thanks, Katlego. Thanks, Alwyn. I think that was a useful, broad national overview. And my first comment is that the national broad understanding of where these farms lie on a national scale is a welcome development. Because historically, most of these farms were managed by different entities of the different homelands. And the data was sitting with those entities. Now, the issue is the entities which were managing those farms were managing and were collecting, storing, and sharing different sets of information with respect to the farms. Now, so this one explains why we have discrepancies. And these discrepancies are likely to live with us for a fairly long time until we have an integrated land information system. Now, coming to the announcement around the farms themselves, for me, the announcement raises more questions than it provides answers because of a whole range of reasons. Farms don't get manufactured. These farms come from our past history, from pre-1994, from our homeland history. These farms were on state land lease portfolios of homeland governments. And on day one of the new dispensation, these farms came into the portfolio of state land lease of the post-apartheid South Africa. Now, we are being told, we as government are releasing state land as part of land reform. This has, in my view, been happening ever since day one of the current government. So, and these farms were on lease, and I don't see anything different that is being done now. The only thing that is being done now is there's more noise and there's more publicity around it. I do question the deadline because there were no deadlines before. These farms, people simply applied and people got rights to them. Some paid leases and so on and on and on. Now, I question this as a land reform, as a new land reform initiative. It definitely isn't. It's old wine in a new bottle. I question the deadline. That one is it's quite a serious one. One of the reasons why I question the deadline on this is the minister in her presentation talks about ascertainment of rights on those farms, which is still to be done. Why would they even make an announcement of this magnitude when that ascertainment had not been done? So for me, I'm very concerned about that. I'm concerned that the land justice imperatives of land reform are being undermined by political opportunism, where the EFF tail in this particular case, and in the past few years, as we have seen with the constitutional amendment processes, where the EFF tail is working the ANC dog, and which is very problematic because it sends the country into inappropriate policy trajectories. Now, the next point is that the spatial location of these farms, while welcome, I'm very concerned about integration and coordination within government, because land reform is everybody's responsibility in government. But unfortunately, up until now, history, through the post-settlement, land reform, post-settlement support, all the evidence suggests that while it's everybody's responsibility, it's no one's job. So everything ends up falling between the cracks. Because if you are going to lease this number of farms to new farmers, as new set of farmers, how, if you have not fixed the structural problem and institutional fragmentation in government, I question if it will be able to raise the floor for the poor. My view on that is that there is no game in place to turn around the institutional and structural fragmentation and incoherence. And the costs for the poor are very high when it comes to this sort of thing. I think I would prefer to stop there. My last point is paucity of data, which by closing off. Paucity of data on these farms. How do people even make an application to lease a farm when there is no data on the table? There should be a variety of data which lies across different departments. Data on vegetation, data on infrastructure, state of the condition of that infrastructure, data on water availability on the farms, data on climate futures. What are the issues around fires and droughts pertaining to related to climate change in the future? Otherwise, if you don't have, there's a whole set of data which is the required for anyone who is going to lease a farm and who's going to embark on serious farming, because you invest because people understand these futures, and without that information, we're setting people basically up for failure. Thank you very much.
Thank you very much, Siyabu, for that thorough explanation, and you raise very important concerns. But my next question goes to Rosalie. Rosalie, you have done extensive work in the past and recently in the Eastern Cape province, and you have conducted several audits in the province, including an audit of Gwaju Landmark, which forms part of the farms included in the state leasing plan, to assist the Eastern Cape government in the allocation of disposal of the land. Were you satisfied with most of the beneficial occupation rights on most of these farms? And you could also take us through your findings as you were doing this work in the Eastern Cape.
Thank you, Katlego, for that introduction and that question. The answer is no. I have massive concerns about the state leasing plan in relation to the Eastern Cape, which is the part of the South Africa that I know best. So we've already had some of the history, but just to reiterate that large swaths of white commercial farmland were purchased by the South African Development Trust to consolidate the former Transkei and the former Ciskei. And just to remind you of the dates, in the former Transkei, this process happened in the 1970s. In the case of the former Ciskei, which was just a bunch of fragmented areas before this, most of those expropriations from white farmers occurred in the 1980s. We are talking about half a century later. So just bear that in mind when I come back to that point about the time span. So these farms were allocated by homeland authorities. Some of them were subdivided, often to powerful individuals and civil servants close to the homeland governments, mostly as lease arrangements. So again, nothing new here. Many of them were subsequently subject to the Special Investigation Unit for Corruption and were unresolved. Some of them were donated. George Matanzima got a farm, Kaiser got a farm, his brothers got a farm, etc. And many of the lessees were absentee farmers. I'm not saying all of them, but probably the majority from what I saw in my field work. But most of the former farm workers stayed on the farms and began to invest heavily in livestock and continue farming, of course, with few resources. Now, just to take you back to some of the policy issues at that time, this history has to be brought back into the foreground. It's been lost. So given the very high priority of land reform in the 1990s and the need to resolve the rights and claims on SADT land, the Department of Land Affairs had a program it was known as the State Land Disposal Program, and there were a huge amount of processes and procedures were quite bureaucratic to bring about disposing so-called state land to the rightful owners and occupiers. And this program, of course, had resolved many legal issues regarding the rightful beneficiaries of this land and how it would be and should be distributed or allocated. So bear in mind, this is déjà vu. This was happening in the 90s. So one of the issues that had to be resolved was the applicability of a new law called IPILRA, the Interim Protection of Informal Land Rights Act, and whether it applied on state land. It was a huge policy issue. It was hotly debated, thoroughly debated. And I presented a lot of very detailed empirical information to the department to help them make a decision about this based on a case near Alice called the Maskane case, which is still a big issue and has also been advertised for lease. And it was eventually resolved after a very thorough process of information gathering and political and debate, policy work, that indeed, in particular cases, IPILRA does apply to people on state land, particularly SADT land. And not just to anyone who happens to be living there. You've got to meet certain conditions. And those conditions would have to be applied for you to qualify for an IPILRA right. But bear in mind, we now have 50 years later, almost everyone who was on the farm then would qualify now. And I have all the documentation to verify, that this process happened, all the information around the projects and programs of the time, the debates and the resolutions that were taken. And I still have, in fact, examples of the submissions that were made to the Land Reform Policy Committee in 1999 in this regard. But I won't read them now. It's too detailed. So in terms of the policy and laws of the department, it was clearly resolved that beneficial occupation applies to farm dwellers who qualified in terms of the definition of beneficial occupation. And the relevant clause is in section 1C of IPILRA. It says beneficial occupation of land for a continuous period of not less than 5 years prior to the 31st of December 1997. That date is still set in stone in the Act, but that doesn't change anything. So there can be no turning back now to these resolutions that were made in the 90s and the noughties, that beneficial occupation applies to SADT land, providing the conditions that were in the policy documents are met. For example, proof of use, proof of actual beneficial use, quantification of the land. You've got to be able to quantify and value the land, recognition of other claims, a condition of no sale for a certain period on confirmation of the rights, etc. So the evidence that was relied on, as I've mentioned, was the Masakane case. Now in Guachu, where I did a thorough land audit in 2000, literally my methodology was farm by farm. We went to every, my colleague Monty Root and I, we went to every single farm, took down all the farm dwellers' names, quantified their livestock, etc., and the same for any other occupiers if they were lessees, for instance. And we provided a detailed set of evidence of who was using the land beneficially, whether it was the lessees or whether it was the farm dwellers. And our conclusion was that in many cases, if not most cases, in fact, it's still in the document, the farm dwellers are qualified for beneficial occupation, and our proposal was that in the case of active use, they should get the farms. Now we have a situation nearly half a century later, where in spite of a long history of contestation and claims to this land, which Thembakazi will go more into the detail of, we are discovering the department is ignoring beneficial occupation, and in fact they're actively arguing, explicitly arguing, that IPILRA does not apply on SADT land, it only applies on communal land. This is patently fallacious. IPILRA applies to all land in South Africa, providing you fulfill the conditions of qualification. It includes urban land. It's not just communal land. That is completely wrong. Now, when we listen to the minister, she sounds terribly logical and reasonable about everything. And when she's asked, when questions are put to her about the contestation and the claims, in particular to Gwachu, she's reassured the public that the process is transparent, and in some cases, it's subject to land rights inquiries to settle conflicting claims. So she's emphasized the transparency of the process to put aside fears and to give reassurance. But her reassurances of a transparency and administrative justice in the case of the Eastern Cape is not at all the case, does not present the reality on the ground. It does not reflect the history, it does not reflect the reality. And in Gwachu, there has patently not been transparency. There have been no less than 3 land rights inquiries, the first of which I did, and there have been 2 since then. The present one was supposed to be completed in 2018. It's still not been made public, even though the land in question has been advertised for applications to lease it. The minister has admitted the land is heavily contested. She was asked in a press briefing, and she admitted it. So we would call on her to justify how her department can advertise farms that are subject to an incomplete land rights inquiry and where the land is heavily contested. Surely the findings of the land rights inquiry should have been released, negotiated and resolved before the land in question was advertised as part of a leasing plan. And this should apply to all state land in South Africa, given it's mostly SADT land. This is not pure state land. It has a particular history, a particular context in South Africa. So in line with what Siyabu was saying, in terms of a land administration approach, we should do what we've been pressing the department to do in terms of an integrated land administration strategy. We need an adjudication and a conflict resolution process for such programs such as these. We have no adjudication law in South Africa to guide these land rights inquiries and to ensure that they follow standardized principles and procedures and to take into account all existing law and customary law. Now, in the case of Gwachu, we don't even know who's conducting the land rights inquiry. Are they lawyers? Are they economists? Are they agriculturalists? We don't know what their understanding is of adjudication of land rights. So without guiding land rights adjudication principles, land rights inquiries rest on subjective interpretations of whoever draws up the TORs and whoever conducts them. I know when I was doing these audits, some other people got some tenders to do other audits, and we did them differently. So in conclusion, I call on the minister to make available to the public the historic resolutions and processes that preceded her tenure in the 2000s, to set up an urgent task team, to set up a process of adjudication and conflict resolution, and to take into account the history and to negotiate a fair and just resolution to these claims. And if this doesn't happen, I can predict that these cases will need judicial intervention and will almost certainly land up in the Constitutional Court. In fact, I can see a Constitutional Court judgment is going to be necessary. Thank you.
Thank you very much, Rosalie, for that. My other question goes to Thembakazi, and which actually touches on some of the aspects that Rosalie and Siyabu have raised. But Thembakazi, can you please share with us the battles of the people of Gwachu in order to get the land transferred to them, and the experiences that you had with the department, and if possible, because of Thembakazi is also one of the farmers, Alwyn, may you please also help us to see the farm in which Thembakazi resides in, and perhaps we could also see what goes on the farm.
Perfect, Katlego. I can. Are you going to share the screen later?
I would suggest that we share the screen as she tells us her story of Gwachu, the Gwachu community.
Okay. Okay, thanks, Katlego, for giving us the platform to share our experiences as the community of Kwaju in our attempts to have the land that we have lived on for generations transferred to us. And I mean, our story is a very long and bitter one. I will just add to what Dr. Kingwill has already mentioned. About Kwaju, just to give you a bit of background before I go to the chronology of events, that we went through to today. Kwaju is like a farming community, in fact, near Queenstown in the Eastern Cape. Those farms were in the previous government owned by white commercial farmers, and they were bought for Transkei government. And when those farmers left, the farm laborers remained, and the Transkei government brought in the people who were called lessees. Currently now we are just doing subsistence farming as the community of Kwaju because there's lack of infrastructure. There's nothing much we can do on those farms. I would say, those 88 farms are just lying fallow. They are not being used productively as we would want to. We struggled for many years as a community of Kwaju to have this land transferred to us, but our attempts failed, I would say, until we decided that maybe there's something that we don't do well. Let's invite a person who may have a better understanding of how this government works and maybe advise us in terms of what we need to do in order to get the attention of the government. So based on the advice of the person that we invited to assist us, we formed a CPA in 2013. And we introduced ourselves to the department, and we followed, the provisions of the CPA Act of 1996. We hired the services of a, legal person. The community of Kwaju, I'm sure, you will know about it. It's just a community that relies or lives on social grants. But we had to collect, some monies for us to be able to pay a lawyer who would assist us in this process of, applying for the registration of our CPA. So we worked with this. We identified a lawyer, within the area, within Queenstown, to assist us. And then we submitted our application in 2014. To the department, which the department never acknowledged. So as we were working with the department, while we were working with the, waiting for our application, the local government, trying to introduce ourselves, trying to get their cooperation and assistance. Unfortunately, all those attempts failed. And then one of the things, in fact, that they mentioned to us is that, for the department to consider registering the CPA, they have to do a land audit, which they conducted without consulting the community, and that failed. So, and then in 2015, we offered to assist, the department to redo the land audit, and then, facilitate the process and work with the community and make sure everybody participates and we involve everyone who lives in Kwaju. That happened. The audit was conducted, completed, and we were given a verbal report in December, 2015, and we were promised that a written report will follow, and that never happened. We had to approach Legal Resources Center for us to be able to have access to the land audit that was conducted in 2015. I won't go into details, but even Legal Resources Center did not get the cooperation of the department, and they had to apply prior for them to get this report for us. So after we got the report, which was totally different from what we were given in 2015, through their verbal report that they presented to us. So nothing happened. It was quiet. We waited. We tried to contact the department, but without any success. And then in 2016, we decided that no, this time we have to go to Parliament, to march in Parliament. And we targeted the date where the minister was going to present or deliver a budget speech. So we collected, monies, social grants again to pay transport to Cape Town. And then when we got there, we met with the department, and the minister appointed a task team to assist us. They promised that they are going to register the Kwachu CPA for us to be, for the land to be transferred to us. And the same minister, while we were meeting the task team that they appointed, he made an announcement in Parliament together with his deputy Mcebisi Skwacha, that they've made an agreement, they've reached an agreement with the community of Kwachu. So we are great that, from the meeting that we had in Cape Town with the ministerial task team, that we're going to meet in Kwachu like 2 days after, where the ministerial task team presented the work plan or action plan. So what steps we were going to, we will have to go through for us to be, for the CPA to be registered. And one of the things at the meeting that we had with the ministerial task team was that, they made a proposal, which according to them was coming from the minister, that while we're working on the restoration of the CPA, we must consider, the pilot project that was, the department was piloting in Mpumalanga and Eastern Cape. And then we agreed, and then we went to see, with the advice and then, proposal that was made by the department, that we were going to see this pilot project in the Eastern Cape. The department paid transport, for us, and we were told that we were going to meet with the minister there together with his ministerial task team. But when we got there, there was no minister, there was no ministerial task team. We just met, a young, project manager. We made follow-ups, with the task team. After that, we wrote to the minister without any success. And that was at that point where we decided now that we need to approach opposition parties to assist us on this. We spoke to EFF first, and then to DA, which is still, assisting us on this. And they put pressure on the department, asking, questions in Parliament, about, Kwachu, the minister's plan about Kwachu, and why, they are reneging on the promise that they made in 2016. So in 2018, the department then conducted the land rights inquiry, and I understand it was at the cost of 400,000, which again failed. So following that, then they had to do another one, which, but they could not come to us and, and present the results, of the failed one to us. So they went through the, DA provincial office to invite us to a meeting, to talk to us so that we can revive the process that we started in 2016, work together towards this restoration of the CPA. So the outcome of that meeting, that was in August 2019, and the outcome of the meeting was that land rights audit was going to be redone. And secondly, the department was going to release a full audit report that was conducted in 2015. And then again, they disappeared. And then a year later, after the pressure from the opposition party in Parliament, they came back to us and they invited us to a meeting, and then that's when we started the land, planning for the land rights audit again. It started in August, and then it was completed, I think, in October. Yeah. And then on the 30th of October, we're invited by the department, to be given feedback of this land rights inquiry. But unfortunately, the meeting failed. It collapsed because while we were there, we were shocked, in fact, when we got there, to see people who do not reside in Kwachu, who called themselves Amachachu traditional leadership, which was led by the former Deputy Minister of Finance. So, and then in the same process, that was when the department had already advertised, there's, the farms for leasing. And to our shock, Kwachu farms were also among those farms that were advertised, for leasing. I know it's a long story, but I'm sure I'll fill in the gaps during question time.
Thank you very much, Thembakazi. Alwyn, I was just wondering whether we could quickly do a brief look at Thembakazi's farm, and perhaps also you and Thembakazi could briefly speak to what we see on the farm.
Yes, 100%. So I think, as we can see, Queenstown, there's Kamahuk, Thembakazi. So what I've done is I've located your farm. It's the one that is hatched here in yellow. As you can see, it's part of the selection of the farms that we found. And then I just, found some really nice aerial photography for that. So let me switch this off. And as you can see, if I zoom into this farm, you can clearly see, a working farm, people staying there. And Thembakazi, you say exactly where this is?
Exactly, that's where my home is.
That's where your home is. Wonderful. Yeah. So
I can even tell you which one of those houses is my home.
Yes, Katlego. So I think very important to share this information and get it out there so that people can, understand if their farms are being part of this selection. And I think we should actually be able to map that as well, and we put a name to the portions.
Absolutely. Thank you very much, Alwyn and Thembakazi, for sharing that with us. We will now move, for the interest of time, we will now move to the questions and comments from the audience. And the first question that I see on my side is from Tabani, Tabani, who asks, plus we are very lucky to have students and all sorts of people from various backgrounds tuning into this session. And he would like to know, what does the acronym CPA stand for? And I see that Strawn has given us a response to say that it's actually stands for the Communal Property Association. But perhaps it would be great for maybe any of you to tell us more about the CPA. Rosalie?
Okay.
I think I would prefer, my involvement in Guachu was actually prior to their formation into a CPA. When I did the audit, farm dwellers were very much living on the farms as they had been before, and were constellated as small family groupings on these farms. And the way I understand it is that the threats to their rights over time made their choices and more and more limited their legal choices, because the Pilgrim was being ignored. So the way I understand it, but Thembakazi can explain if I'm right, that the CPA was the one way of trying to preserve and make their rights more visible. But Thembakazi can answer the question.
Yes, thanks, Dr. Kingwill. CPAs, I think, is one of the mechanisms, in fact, made available by the government to give land to the people who live on, especially people who live on communal land, like, the people of Guaju. So we use that act because we found it more suitable in our case, because that's communal land.
Thank you very much. There's another question.
I can quickly also just come in to say that, just to have some perspective, there's about 1,600 plus CPAs in the country, and they're distributed all over the country as a legal entity by government when land restitution took place.
Thank you very much.
Yes.
Yeah. And there's a question from Ruth Hall, and she asks, so they are only outside the homelands in the sense that they are registered as farms or cadastral system?
I think that's a question for me.
Okay, yes.
Yes, so as part of the Surveyor General's data set, where they have a spatial boundary for each of the farm portions that are registered in the country through the deeds office. So yes, they have been registered, they have a Surveyor General code, and they're all legally registered. So we can follow, the property's history to say who did it belong to, who was it sold to, for what was it sold. So all that information is available if we so choose to investigate.
Thanks, Alwyn. Next question, please. So our next question is from Siyabu Manona, and she's asking, the land acquired by SADT, how good is the quality of this land? Do any of you have an idea? Rosalie, you spoke a lot about the SADT and you've done research there. Can you perhaps provide us an idea of how good the land is?
Yes, I see it's Sienna.
Yeah.
Sorry if I'm pronouncing your name wrongly. I don't know about the land outside of the Eastern Cape. I can only speak for the land inside the Eastern Cape that was acquired by the SADT. It was all previously farmed by white farmers. And I would say most of it's very high quality land, but for very different purposes. I mean, Guachu is clearly livestock farming country. It's not really arable. Whereas there were other parts in Mpofu district, that's Stokenstroom or Seymour, that was regarded as the garden of the Eastern Cape. There are now citrus farms and so on there. There was once tobacco farming, unfortunately. So it varies enormously. I don't think there's going to be one single answer to this, but I would say in general, certainly wouldn't be bad quality land necessarily. I don't know if somebody else wants to come in on that, Siyabu or somebody else.
Yeah, my quick response on that is relates to the initial comment I made, that when one is embarking on a project of this nature, one needs data. Many of these farms, I'm very familiar with many in the former Sky. There's been a lot of deterioration, poor management over the past 25 years, invasive species coming in. This doesn't really contradict Rosalie's point that the land may have high potential, but invasion of foreign species and all of that due to poor management has been a big problem, at least from what I've been seeing in the Eastern Cape. So for me, it's not about just the quality of the land. It's also about the futures. The futures are climate change. What are you putting people to? Are you not putting them to future dangers? Are you not putting people where they should actually be removed? Because climate change, land reform imperatives are totally different to land justice, land reform imperatives. And what you can do with land now, given climate change, is totally different what you would have done 2-3 decades ago. Thank you.
Now, for the interest of time, and also bearing in mind that our panelist Siyabu Manona has to quickly jet out, our next question is from Ruth Hall, and she asks if the government says Ipilra law does not apply because of its titled farms, then ESTA law should apply just as it does on other farms.
Just before I leave, because I've got about a minute or two. Basically, these farms being state farms puts them in a totally different category to other state land, because this is private land which was destined for homeland consolidation in many, that was the intention. So IPILRA, I support Rosalie's point, IPILRA does apply on these farms. I would not move on to argue about Esther, because I am fairly confident that from a legal point of view, IPILRA applies on these farms. Thank you.
Thank you. Rosalie, yes?
Yeah, I'll come in on that. Thanks, Siyabu. That's good. We're on the same page. That argument that they're bringing forward about titled land, Pura and Esther are not governed by whether a farm is titled or not. It's to do with your conditions of tenure in a way. So Esther applies to people who have some type of contract. In other words, you have permission to be on that land because you have an employment contract with the farmer who owns the land, or you are recognized, you're allowed to be there as a tenant, or you're allowed to be there as a family of a worker or tenant. You are given permission to be there. That's Esther. There's some link with a contractual relationship, and you're allowed to be there. IPILRA is more like a prescription right. It means you have not been given permission to be there, but you have lived there for a certain length of time. Now, in the common law, it's 30 years. If you've lived there with no permission for 30 years, you get prescription rights. In this case, it's different. IPILRA was 5 years, and in terms of the proposed land rights bill that was scuppered, they were thinking of increasing it to 10 years. But the point is, it's at the moment, it stands as 5 years from 1997. And it means you have no contractual relationship with anyone. You're not permitted to be there, but you've been there and no one has chased you away for that length of time. So that argument about title is totally off on the wrong legal tracks altogether.
Wow. Thank you very much for your contribution, Rosalie. Our next question is from Emily Schaffer, and this is a question for Thembakazi. Could you please provide more detail about why the successive land audits conducted by the department kept failing, and what does the failure mean in that sense?
I think the main reason for these failed, audits is because of corruption, nothing else. They were done not to help, the people like in the community of Kwachu, the people who lived there. They were done to give a different picture, about Kwachu, a picture that will help them to do their corrupt activities. So, and then we challenged them. Then they had to be redone, and unfortunately, that happens at the cost of, taxpayers' money.
Thank you very much for that answer. Just for the interest of time, I guess we can take one more question. And that's from Polani Lwana. And he asks, the Department of Land Affairs, what is the objective of land reform if Mama Thembakazi is still struggling through the CPAs to get land? I guess that's a general question. Do any of you want to take it? But yeah, anyway, it's a statement. And Vuyelwa Manki, I'm going to try, forgive me for pronouncing your name wrong. And she asks, has the Kwachu community applied under this new scheme from the department, whether you've applied for land under this new proactive land acquisition strategy? Has the community done that?
No, for us, that is not applicable because, the department has already made a commitment that they are going to register the CPA of Kwachu, which means transferring the land of Kwachu, to the people of Kwachu. So there's no need for us to apply. In fact, even this now, the leasing of, a land that, that the minister has just, done, we communicated with her. We sent her an email that for us, we are not going to apply, for these, leases, because for us, we're still waiting for the department to deliver on their promise to register the CPA of Kwachu.
So I would like to come in there. The provincial office of land affairs, when interviewed, stated evidently, and I'm just saying this evidently because it's secondhand, that they wouldn't be eligible even to be lessees. They would be regarded as tenants, not even lessees, let alone owners. But that will come out in a planned special assignment that a journalist, Hazel Friedman, is busy preparing. She's got the notes of that interview, but that seems to be what they were indicating, that they're not even regarding the Kwachu people as potential lessees.
Okay. For the interest of time, we'll move on to our next question and final question, and that's from Jan de Lange, and he's asking, are there any of the speakers aware of the working farms under the control of successful emerging farmers who are in a similar position as the Kwachu farmers? Thembakazi or Rosalie, since Siyabu has left us. Yeah. Are you aware of successful emerging farmers who are in similar?
I think someone like Ruth Hall would be a much better person to speak to this, but I can only mention the other comparable example near Alice, the Masakani CPA. That's also, there are two little CPAs right next to each other. They're in very similar circumstances. They were also very heavily invested in livestock. And their CPA was registered, and it was the land was, I thought, transferred, but evidently their land has also been advertised for leasing. But in terms of the more general question, I'm not really the expert to speak about that. Someone like Ruth might want to, at some stage, answer on the comments page.
Oh, okay. Now we have reached the end of our webinar for today, and thank you to you all for participating in this ongoing debate, and we will continue keeping an eye as to what will unfold. But then I think what we have all, or we all agree with, is something that Siyabu confirmed, that there is poor integration, lack of coherence in land reform, and it is, everyone's business, but nobody seems to be doing the job. So I think we will all end it here, and thank you all to our participants for joining us.